everyone to the Clad Possible official YouTube channel. Today we are going to talk about a topic which is trending, which is all over your newspapers. There are a lot of editorials that are there with respect to this topic, and it becomes exceptionally important for your competitive examination. But before we start off with this topic, I'd like to tell you about certain initiatives that have been taken up by Clad Possible just for our students. So the very first thing is, when you see our Clad Possible official website and our social media platforms, you will be able to find the most important headlines of every day. This is being continuously updated just for our students. Kindly go through them, kindly learn them up, ask your questions from your teachers. The second thing is that every day we are coming up with minimum 5 questions which is presented to you in the form of a quiz. You can go and attempt these questions and you can check these answers and learn them up. These particular questions will be relevant to that day and the news that has come up on that day. And the third thing is something called On This Day. So for example, today is the 21st of January 2023. If in case any important historical event has ever happened on the 21st of January, we've consolidated all of those events and we've put them at one place for you. So all you have to do is you have to learn this up. So these are the 3 things that you can do on your own every day so as to make your preparation even better. Now, let's start off with the topic at hand. Now, the very first thing is, we'll come to the topic, but first let's understand why this is very important. Right, we do understand that India is running on the principle of rule of law. Now, so the principle of rule of law, of course, law is made by people who are in the legislature, but it will be wrong to say that these people in the legislature can make any kind of law that they want to. Their powers are limited, and their powers are limited by virtue of the Constitution, which is the highest rule book of our country. Now, today in the Indian Express, there was a very beautiful editorial with respect to constitutional morality. So first, let's understand what is the meaning of constitutional morality, and then let's understand the entire debate on the appointment of judges. Yes? So now, what is this constitutional morality? You have to understand that ours is a written constitution. But however, it is absolutely impractical to think that each and everything has been mentioned in the constitution explicitly. Right? Hence, we have the judiciary, which is the highest interpreter of this constitution. So, for example, Article 21 that talks about protection of life and personal liberty except according to the procedure established by law. Now, protection of life, if we look at the term life, life does not merely mean breathing. Life means that I can live my life in a dignified manner, make the right choices, and till the time I am working within the ambit of law, nobody can actually stop me. So the question in hand right now is that, whatever is the process of appointment of judges, that's a separate thing altogether. We'll deal with that, and that is primarily why we are here and we are making this video. But the question that I'd like to put out to you is that should the sexual orientation of a judge be one of the factors that you need to keep in mind while thinking of whether this particular person should be elevated to the position of a Supreme Court judge or not. A simple भाषा में एक इंसान को हाई कोर्ट के जज से सुप्रीम कोर्ट का जज या फिर हाई कोर्ट का जज भी बनाने के टाइम पे jitne bhi are factors you're keeping in mind, should that person's sexual orientation be one of the topics at hand. Now, that is something that we are going to deal with. You must be reading about it in the newspapers. Coming back to this term constitutional morality, this basically means that, as and when the times change, people change, the society changes, and so does the need of the society. Long back, we used to think of, live-in relationships as something which is really bad. Of course, a lot of people in the society still look down upon it. But however, the question comes into play that, if two people who are of marriageable age, who are majors, if they wish to stay together, is that right or is that wrong as per the constitution? Now, of course, we can't go back to the Constituent Assembly and ask them this question. So who's going to give us this answer? That organization or that institution is the judiciary. And that is the job of the judiciary, to keep in mind the trends of the society, the needs of the society, and to see whether those needs are actually compliant with what was the heart and soul of our constitution, and that is what is the constitutional morality. Now, the second point that I wish to discuss, and then we will go on to the appointment criteria, is the doctrine of checks and balances. Now, what is the doctrine of checks and balances? So we do realize that in our country, we follow something called the doctrine of separation of powers, which basically means that the law-making authority is given to the legislature. The law, who will implement the law, that job is with the executive, and the job of interpreting the constitution and interpreting these laws or checking these laws, checking the applicability of these laws, has been given to the judiciary. Now, where does doctrine of checks and balances come into play? Very simple. If tomorrow people in the legislature are not representing their electorate faithfully, what if we realize that the people sitting in the Lok Sabha are not representing their electorate faithfully? Who's going to put a check and balance on them? So that authority has been given to the executive. In our constitution, there is a provision that gives power to the Prime Minister of our country to go and tell the President that, listen, these people who are sitting in the Lok Sabha are not representing their electorate faithfully, and let's dissolve this Lok Sabha before its stipulated 5-year term. Secondly, what if the executive is not doing its job well? What if tomorrow the executive is going outside the ambit or outside the scope of the limitations that have been put on it by the Constitution? Who's going to check them? A, the legislature can, through multiple provisions, something like, you must have heard of it or you'll hear of it later on. There's something called the question hour and the 0 hour, where the members of the legislature can question the executive as to whether they're doing their job well or not, right? There is also something called the no confidence motion, wherein we can remove these people in the executive because we don't have any, it's very simple, we don't have any confidence that these people are doing their job well. Apart from that, the checks and balances on the legislature and the executive can also be applied by the judiciary. Yes, so of course we've all heard of a prime minister whose entire election was questioned in the judiciary. Yes, I'm sure that you know whom I'm talking about, and I would like you to participate in these classes, right, by writing down these answers in the comment box. This is not for anything else. This is just so that your teachers realize that you are in fact getting involved. Secondly, that you're doing your homework. Yes, so the executive and the legislature can also be checked by the judiciary. Now, what about the judiciary? Can somebody check the members of the judiciary? Can somebody go and question a Supreme Court, High Court judge? Well, the only thing that can happen is impeachment. Yes, we can remove a Supreme Court or a High Court judge through a process of impeachment. And who will do that? The legislature can do that. Fine. So there are checks and balances on each and every one of them. So what are we talking about today? We're talking about a certain, okay, let me put it across to you in this manner. Whenever we go to a job, we apply for a job, we need to know the criteria laid down for that job. I need to know that this is what my employer seeks in a candidate, and then whether or not, I'm able to provide that. Fine. So that kind of transparency needs to be there so that I will be able to align my goals. If that is my goal, the job is my goal, then I can align my qualifications according to that. And then, there needs to be a certain sense of transparency, because otherwise there'll be a lot of nepotism, and nepotism in itself goes against the concept of constitutional morality. अब ये कैसे हो गया? इसका मतलब ये है कि मेरे कॉन्स्टिट्यूशन में, मेरे संविधान में लिखा है that each and every person should have equal opportunities in cases of public employment. Now, equal opportunities in the sense I can go and at least apply for something for which I am eligible. But what if there is an absolute opaque system, right? And I don't really understand that, why has X been elevated to the post of a High Court or a Supreme Court judge, and why not Y? I mean, both of them are sort of meritorious. Both of them have done really well. And why is it that only a certain section become this, a part of the Supreme Court, and the rest of them don't even get the opportunity to do that? Now, that is where the concept of appointment of the judges comes into play. And what is the government trying to say? The government is trying to say, please bring a little bit of transparency. And how will that happen? If judges are appointing judges and the executive has nothing to do with it, it may happen that, you are creating an empire within an empire, right? Let us put our bit in it. Let us also, have a little bit of an opportunity to be a part of the selection procedure, the appointment procedure of a Supreme Court judge, let's say. So, which is why currently the Collegium system is being questioned. Your Union Law Minister has also sent a letter to the Chief Justice of India stating the same, that let's involve the executive in the appointment of the higher judicial posts, right? Now, we will go on to that, but first, in order for us to understand this particular thing, we need to know how a judge is appointed. So, let's start it off. What are we talking about? We're talking about the appointment of judges, or the appointment of Supreme Court judges. Now, what does the Constitution have to say about it? Now, according to the Constitution, Article 124, it says this appointment shall be done by the President, and President shall consult judges of Supreme Court, judges of High Court. I've written High Court because of the fact that, a lot of you might be confused कि अच्छा High Court है तो state है तो governor appoint करता होगा. नहीं, High Court के judge को भी president appoint करता है, because of the fact that our judiciary is integrated, it is not divided. But let's deal with that later. Let's first understand this. Now, the very first thing that we can see is president. All right. Now, how does Draupadi Murmu take her decisions with respect to constitutional provisions? Now, that has been clearly defined under Article 74 by virtue of the 42nd Amendment Act of 1976. It has been said that whenever the President shall take any decision, the President has to abide by the aid and advice of the Prime Minister and its Council of Ministers. Of course, this aid and advice can be sent back once for reconsideration. This came by virtue of the 44th Amendment Act of 1978. Let me write it down again. So, by virtue of the 44th Amendment Act of 1978, Moraji Desai's government, unka nara tha, save democracy, right? So, this said कि ठीक है, President has to listen to the aid and advice of the PM and the Council of Ministers, but such an advice can be returned for reconsideration once. In simple language, Draupadi Murmu can tell Prime Minister Narendra Modi and his Council of Ministers that, listen, fine, I have to abide by your aid and advice because this is not the United States of America. We do not have a presidential form of democracy. But you see, you have to please reconsider this. Okay. Now, two things can happen. Either Narendra Modi and his entire Council of Ministers will be like, okay, I think what Draupadi Murmu is trying to say, our president is trying to say, that makes sense. Let's listen to her. Or secondly, they may say, fine, we've understood your point, but we still want to go ahead with what our advice was. The point is, once that advice comes back, once Draupadi Murmu has sent this advice for reconsideration to Prime Minister and Council of Ministers, whatever be the result, when it comes back to her, she has to say yes. Okay, so that means when I'm writing president, it's actually the prime minister and the council of ministers which are giving this binding advice to the president to do whatever she has to do. Now, the second term that we can see is consult. Now, this is where the bone of contention lies. Because kids, we've not really used the term consent, we've used the term consult. And consult basically means a mere exchange of ideas. You're consulting with somebody, you may or may not agree with that person. आप सिर्फ बात पूछ रहे हो उनसे, ठीक? और अगर सिर्फ बात पूछ रहे हो, क्या कर रहे हो? अपॉइंट कर रहे हो जजेस को, and you're just asking the judges, listen, we think this guy should be appointed, what do you think? अच्छा, you don't think so? Forget it. This is what we think and this is what we are going to do. Now, in case that happens, there will be a lot of involvement of the executive in the appointment of Supreme Court judges and High Court judges. Now, how's that bad? Well, you see, if you are a Supreme Court judge and I'm a part of the executive and you have the right to put a check and balance on me, and somewhere down the line, I am the one who's appointing you, there might be a little bit of personal bias. And I may or may not be able to be that neutral. And if there is so much of interference of the executive within the judiciary, then what happens to the basic structure that says independence of the judiciary is super important? It is one of the most important parts of the basic structure of the Constitution, which cannot be amended. I do realize that the Vice President is talking about time to revisit the basic structure, and we'll deal with that later. But right now, too much interference may compromise the independence of the judiciary. I'm not saying it shall, I'm saying it may. And even if there is a 0.01% chance of compromising the independence of the judiciary, we should not go to that path. Now, that is my subjectivity. Yours can be different. And I really want you to think about it because there are pros and cons to both. Now, let's get back to this. So, consult का क्या मतलब है? ये अभी हमने interpret करना है. And we will have three, first judge's case, second judge's case, third judge's case, three judicial interpretations of the term consult. And we'll get down to that in 2 minutes. Another thing is, we have to consult judges. So they've not said that you have to consult a judge. The Constitution says that you have to consult judges. And since we're talking about Supreme Court judges here, right? How many Supreme Court judges are you going to consult? Is it the entire amount? I mean, जितने भी Supreme Court के judges हैं, सबसे जाके पूछना पड़ेगा कि half से ज़्यादा जाके पूछना पड़ेगा? That is a little unclear. And whatever is unclear, that shall be interpreted. Of course, that is the meaning of interpretation. So now let's start interpreting. ये समझ में आ गया. Here we require a little bit of interpretation, and even here we require a little bit of interpretation. Okay. So I'm going to erase this, and let's start off with the first judge's case. Now, so this is also known as the S.P. Gupta case, which happened back in 1981. All right. Now, what does the S.P. Gupta case say? It says that the term consult means mere exchange of ideas. Which basically means, listen, mere exchange of ideas, you may or may not agree with it. Which then means that the president will consult judges of the Supreme Court, and whatever the judges of the Supreme Court say, the president may or may not accept it. Simple as that. This is also compromising the independence of the judiciary. And so hence we came up with the second case. Now the second case is the Supreme Court Advocate on Records case. The Supreme Court Advocates on Record case, this happened back in 1991. They said, listen, what about the independence of the judiciary? Keshananda Bharti case mein 1973 mein Supreme Court has very explicitly said that there are certain things that cannot be interfered with, and amongst them, through many judicial pronouncements, we've realized amongst them the most important will be a wrong statement. One of the important parts of the basic structure is the independence of the judiciary, which cannot be compromised. Otherwise, there won't be any rule of law. And then what will we do? Okay, so now in this particular case, the Supreme Court said, listen, firstly, the term consult now will be interpreted as concurrence. मतलब माननी पड़ेगी बात. Whatever the judges of the Supreme Court and the High Court say, you will have to listen to them. That's the first thing. Fine. Sorted. Independence of the judiciary को थोड़ा सा हम लोगों ने ज़्यादा अहमियत दे दी. Now, what about this judges thing? Like, how many judges do we have to go and ask? So, in this particular case, they said, you ask the Chief Justice of India and you ask two senior most Supreme Court judges. When you have to appoint a Supreme Court judge, which is fine, this makes sense. But you see, there's a little bit of an issue. When the CJI and the two senior most Supreme Court judges, both of them say, okay, so this is case one. CJI plus the two senior most Supreme Court judge, they all say candidate X. Candidate X will become the Supreme Court judge, not an issue at all. What if the Chief Justice of India says candidate X and two senior most Supreme Court judges say candidate Y? Now, whom are you going to listen to? Because if you are taking decisions as per majority, you should ideally listen to them and make Y the Supreme Court judge. But if you are making Y the Supreme Court judge, then what about the Chief Justice of India? You call him first amongst equals. That means he has no veto power, he has no casting vote. He is basically like any other Supreme Court judge. Then why do you call him a chief? And why do you say he's first amongst equals? Chalo, on the other hand, no, we are not going to listen to them because he's the chief. X will become the Supreme Court judge. And why have you kept these two over here? Why are you saying that we have brought forth a formula or a system wherein judges will appoint judges? Because my constitutional provision says you have to ask judges. You are asking only a judge. Yeah, so there was a little bit of a loophole there. Some things that were not very clearly defined. Okay, over here there is something that I'd like to tell you is the birth of the Collegium system was because of the second judge's case or the advocate on records case. We'll also call it the second judge's case. This is the first judge's case. So in case of a question which says, which judge's case brought forth the Collegium system, you will say the second judge's case. What is the meaning of Collegium? Judges appointing judges. Simple as that. But we do realize that there is a little bit of an issue with the CJI plus two senior most Supreme Court judges. Also, who is senior? How do you decipher who's senior? Is it in terms of age? Is it in terms of experience? Is it in terms of who cleared his judicial examination first? Or is it according to who took an oath as the Supreme Court judge first? And so the answer to that particular question is the last one, the last option. How do we understand that who is senior and who's not senior? We do not look at age. We do not look at their entire judicial experience. We have to just look at this fact कि कौन इंसान पहले सुप्रीम कोर्ट का जज बना, उसने ओथ ली है, तो वो सीनियर है. अगर पहले ओथ इसने ली है, इसने उसी दिन बाद में ओथ ली है, दोनों का एज सेम है, दोनों का बाकी एक्सपीरियंस सेम है, then this guy is going to be the senior because he has taken an oath first. That is how you decipher seniority. That is absolutely clear. But this is not clear. And whenever something is not clear, there is a provision in the Constitution that allows the union government to ask legal advice or to get legal reference from the Supreme Court. The article that I'm talking about is Article 143 that clearly stipulates that in case the union government has any question of law, they can ask the Supreme Court for a legal advice. And advice, of course, is not binding in nature. But however, yes, I can ask that advice. Some may say, अरे advice लेना है तो attorney general से ले लो, ले सकते हैं, ऐसा कोई बड़ी बात नहीं है, दोनों options हैं. So in 1998, we asked the Supreme Court to make it even more clear. We said, how are you appointing these judges? Is it on the basis of majority, or do you require the Chief Justice of India to put his thappa? Only then will somebody be appointed? We are not getting it. Kindly explain it to us. And so comes the third case, which is not really a case per se. It is just a mere reference or a question of law that has been asked by the Union government from the Supreme Court. Right. So let's erase this and let's go down to that. Now comes my third judge's case. 1998. Now things are going to become even more simple, right? What did they say? So they said concurrence is important. You have to listen to the Supreme Court judges. However, now they've expanded the Collegium system and they've said who will be a part of the Collegium system? The Chief Justice of India and 4 senior most judges. So in total, there'll be 5 people in the Collegium system. All right. There were a couple of more things that were said. Of course, some of you might be thinking that, ma'am ne to bola 5 hone chahiye Collegium mein. Justice DY Chandrachud ke Collegium mein to zyada hai. Justice KG Balakrishnan ke Collegium mein to aur bhi zyada the. Aise kaise ho sakta hai? So certain other things that were said were, firstly, that the next probable CJI should be a part of it. Okay, so the next CJI should be a part of the Collegium. And then there were many other things that were said in this particular case, but this is what we have to keep in mind. And they also said that if 2 judges are saying no, then you should ideally not proceed with such an appointment, because you see, these are the best minds, legal minds of our country. Give them that kind of importance. If they're saying no to somebody, they have their reasons. Kindly respect those reasons and don't go ahead with it. It's as simple as that. So, keeping this in mind, now we've understood how this procedure, how this entire appointment procedure is taking place. So we do realize that the qualifications of a Supreme Court judge primarily is that he should be or she should be an Indian citizen. Apart from that, either that person should have 5 years of experience as a High Court judge or 10 years as an advocate of the High Court, or should be an eminent jurist personality as opined by the President of your country. Now, how will this happen? So let's say there is a vacancy of a judge in the Supreme Court. Okay. Now, how are we going to proceed with it? The Collegium will start talking about it. They will start suggesting names and they will shortlist those names. Meanwhile, the government can also suggest some names. ठीक है, सजेस्ट कर सकते हैं, इम्पोज नहीं कर सकते. ठीक है, सजेस्ट कर दिया. सजेस्ट करने के बाद फिर क्या होगा? क्योंकि मेरा आर्टिकल 124 क्या कहता है कि हु इज गोइंग टू अपॉइंट दिस पर्टिकुलर पर्सन एज अ सुप्रीम कोर्ट जज? द प्रेसिडेंट. सो दिस गोज टू द गवर्नमेंट, राइट? नाउ 2 things can happen. Either the government quickly they say yes, or they can return it for reconsideration. Collegium reconsiders it. Either Collegium says, yeah, the government is correct, we should not appoint this person. Or the Collegium says, listen, this is our authority, we want to appoint this person. We don't care, or we are okay with whatever your suggestions are, but we don't want to go ahead with it. Regardless of the consequence of this particular thing, I mean, if this file is sent back with the same name or a different name, the president has to say yes. तो ठीक है, अब हमने सारी की सारी अथॉरिटी किसको दे दी? हमने जजेस को दे दी. अच्छा, इसमें एक चीज है, one thing that is not mentioned anywhere. In how much time will they say yes? What is the time limit? 1 दिन, 2 दिन, 1 महीना, 2 महीना, 4 महीने, 5 महीने, नहीं mentioned. So for example, the guy that we're trying to elevate, okay, so there is a Mr. X, let's say, and that man is, or the lady is 64 years of age. All right, she's the High Court judge. We're planning to make her a Supreme Court judge, and we are all aware that the maximum age of a Supreme Court judge is 65 years of age. What if they don't say anything for the next 1 year? ये तो बेचारे कभी elevate हो ही नहीं पाएंगे ऐसे. So एक तो question यहाँ पे है कि भाई time limit is not prescribed, right? Secondly, how will we go about it? Certain rules and regulations with respect to the collegium, with respect to the appointment procedure, with respect to who should be the Chief Justice of India, when should the law minister go to the current Chief Justice of India and say, listen, please tell us the next probable candidate so that there can be a smooth transition. All of that has been written in the Memorandum of Procedure, which was made in 1999. Okay, 1 year after that. But the government says, and the Supreme Court has also said it time and time again, that we need to amend it, we need to solidify it, we need to make it better, which hasn't really happened yet. Okay? All right. So, now this is the third judge's case. We've understood how the procedure happens. Now let's understand what they're trying to say. Now, what is the government's perspective and what is the judiciary's perspective? And then you will tell me that how, according to you, who is wiser and who is saying the right thing. Now the judiciary says that if the executive is involved, then this compromises the independence of the judiciary. And listen, this has happened before. And the judiciary has made it unconstitutional and void. When did this happen? You all must have heard of it. This happened by virtue of the 99th Constitutional Amendment Act of 2014, wherein, what did the executive say? They said, Collegium system hatao, naya system banao. Kuch aise group of members banao who are going to come and they are going to appoint the judges of the Supreme Court and the High Court. And who all will be involved here? So the chairperson of this particular committee, what is this committee called? NJAC. National Judicial Appointment Commission. Okay, इसके लिए constitutional amendment कर दिया. Chairperson कौन होगा? Chief Justice of India. फिर क्या होंगे? 2 senior most Supreme Court judges. ठीक है, इधर तक ठीक है. इसके बाद कहते Union Law Minister होगा. Then they say there should be 2 members, out of which at least 1 member should represent the SC, ST, OBC, women or minority community. And who will appoint these 2 members? There will be a committee comprising of the Prime Minister, the Leader of Opposition, of Lok Sabha. And in case there is no leader of opposition of Lok Sabha, then we are going to choose the leader of the largest party, okay, which is therein, largest opposition party. So there are a little more points, but what we are trying to understand over here is there is another thing that they said. In case the law minister and these 2 members say no to somebody, that person shall not be appointed. तो फिर क्या हो रहा है? Executive is getting involved in the process of judicial appointments, and according to the judiciary, it would comprise the independence of the judiciary, जिसके कारण इसको किसको NJAC को हमने क्या बोल दिया? This is void. It is unconstitutional and it is void. खत्म करो बात. अब तो वापस से क्या चीज आ गई? Collegium system. We said collegium system zindabad. This is how it's going to happen. Now, what is the government saying? What is the government's perspective? It is saying involve the executive. Firstly, why should we involve the executive? Because it should be transparent. The procedure should be transparent. We don't want any nepotism, which according to them is happening right now. तो किसी भी जॉब में इक्वल अपॉर्चुनिटी होना चाहिए. And opportunity के लिए मेरे को criteria तो बताओ. What is the criteria? Why is one guy getting elevated and the other guy is not getting elevated? What is the criteria? what are the minutes of your meeting? What do you talk about when you sit and you discuss these things in your meeting of the Collegium? So such things we are unaware of, and we are scared that, this particular organ, which is supposed to uphold the constitutional morality, is it able to do that properly, or is it unable to do this? So this is what is in news. Kindly go and read these articles and let me know what you think about this entire thing. Is the government correct, or is the judiciary correct? Should the entire collegium system be scrapped out? Should there be an executive involvement within the collegium system? Right? Think about it and let me know. Right? Thank you very much, and I will see you soon with another topic. Thanks a lot.